Good afternoon, everyone, and welcome. My name is Emily Martin. I'm NCEDA's Program Manager, and we're excited to have you with us. Before getting started, I'd like to review the logistics of this webinar platform. You'll see on the screen a few important logistics to read through as attendees. To reiterate, all attendees are muted and will stay muted during the presentation. The best viewing option for your screen is called Speaker View, which you'll see as a viewing option at the bottom of your screen. We will have a live Q&A session at the end of the presentation. During that segment and anytime during the presentation, you can type your question into the Q&A box. To access this option, click Q&A at the bottom of your screen and then type in your question. These questions will be addressed at the end of the presentation. If we are unable to answer all the questions live, NCEDA will send out a response sheet to all participants afterwards. Please note that we will be answering questions from the Q&A box, not the chat box. We won't be checking that regularly. This webinar is being recorded, and a link to the recording will be sent to all registrants to use as a resource. At this time, I'd like to introduce NCEDA board member Mark Pope, who will offer welcoming remarks and introduce our presenters.
Thanks, Emily. With only a few exceptions, businesses across North Carolina are again operational now that the state's phase 2 reopening is underway. That means companies and communities in all 100 counties are welcoming back customers, employees, visitors, and business partners. Meanwhile, the COVID-19 pandemic is far from over, with new cases reported every day and hospitalization rates at alarming levels. What does this mean for economic development organizations and the businesses they serve? I'm Mark Pope, immediate past resident of NCEDA and president of Wayne County Development Alliance. I'm happy to welcome everyone to today's webinar, Opening for Business During the Times of COVID-19, Key Considerations for North Carolina Businesses, sponsored by Smith Anderson. Our expert presenters will take over in just a minute. First, let me thank Smith Anderson Law Firm for their sponsorship of today's webinar and for their long-time commitment to NCEDA. We're grateful for all their support for the economic development community in general and for NCEDA specifically. Now is also a great opportunity to thank all of NCEDA's annual sponsors. Emily is scrolling their names and logos across your screen right now. We appreciate their support 24/7, 365 days a year. We couldn't produce meaningful professional development webinars like this one without them, so thank you. The success and survival of the most businesses center on minimizing risk while maximizing return. The Daily Balancing Act largely separates those companies showing a profit from those suffering losses. The COVID-19 crisis has made this already difficult challenge even more complicated. How do businesses embrace the opportunity to reopen while not exposing themselves to new liability concerns? Today's webinar explores these new realities. With us are two experts who will walk us through this difficult terrain. I'll introduce them now. Steve Paradis-Gandola heads up Smith Anderson's Governmental Affairs, Administrative, and Regulatory Law Group. His practice includes environmental and OSHA-related areas. Steve is recognized as one of the North Carolina's leading environmental, health, and safety lawyers by all the major legal ratings services. He holds a BA from Eckerd College and earned his law degree from Stetson University, where he made law review. His colleague, Chris Smith, co-chairs Smith Anderson's business litigation team. He is a trial and appellate lawyer who counsels clients on business strategy. Chris offers advice on business risk management across a wide variety of areas. He also serves on the management committee at Smith Anderson. Chris holds both bachelor's and law degrees from the University of Pennsylvania, where he was Phi Beta Kappa. Our thanks go out to Steve and Chris for leading the discussion today. Thank you both, and I'll now turn the webinar over to Steve Paradis-Gandola.
Hello, everyone. Thank you for joining our webinar today regarding opening business during the coronavirus pandemic. Next slide, please. Two things are on everybody's mind these days: safety and liability. And we're going to discuss today both some of the safety aspects regarding reopening, as well as some of the liability protections here in North Carolina that have been promulgated by the North Carolina General Assembly. Next slide, please. This is my presentation. As Mark mentioned, I head up our environmental health and safety practice here, including our OSHA practice. A lot of folks are new to OSHA. It is the Occupational Safety and Health Administration, also the Occupational Safety and Health Act. Both get referred to commonly as OSHA. And lots of people who never really had much reason to know about OSHA are learning about it now. All you have to do is go into an office these days, like ours, where you see pictures of feet of where to stand in an elevator, or signs saying only one person in a restroom, masks everywhere. It's a topic that is on everyone's mind these days for obvious reasons. First, because we don't want to get other folks sick, and also because people are reasonably worried about potential liability. Next slide, please. So let's talk about OSHA. It is the primary law governing worker safety in the United States. It is primarily comprised of a bunch of rules which say what you can and can't do in a workplace, or what you do or do not have to do as an employer to protect your employees. In some cases, some industries have standards devoted specifically to them. For example, the construction industry or the healthcare industry, that have groups of rules that are applicable just to them. There's also lots of OSHA guidance documents and letters of interpretation, other things that help explain what employers are supposed to be doing here in the United States. And sometimes OSHA incorporates or refers employers to guidance developed by the Centers for Disease Control and Prevention, commonly known as the CDC. If you think about it this way, the CDC, specifically the National Institute of Health, which is a sub-agency, evaluates appropriate safety measures in the workplace, while the OSHA folks actually enforce and supervise safety in the workplace. In addition to these specific rules, there is something called the General Duty Clause in the Federal OSHA Act. And it is a clause that mandates employers to protect their employees from recognized hazards in the workplace. And that sounds fair enough. It sounds almost even easy enough to comply with. But whereas with rules, you can see exactly what you are or are not supposed to be doing, with that general duty clause, what makes a workplace free from recognized hazards can sometimes be a subjective opinion determined by a given regulator or inspector. And in these days, when you have such a novel hazard in the workplace, such as coronavirus, it's more important than ever to try to figure out, beyond the rules, what should I be doing as an employer to make sure that I'm protecting my employees from recognized hazards in the workplace. Next slide, please. I call this my elevator pitch. You hear in marketing a lot about how you're supposed to be able to sum up what you do or what you sell in the time it takes to ride a couple of floors in an elevator with someone. When people ask today, how do I stay out of trouble with the OSHA folks? I can bundle that advice into three primary things. One is, obviously, employers have to pay attention to federal, state, and local reopening criteria. If you get out in front of your skis on that, you're just asking for trouble from both the OSHA folks and maybe even the state and federal departments of justice. The other thing is checking carefully OSHA rules and guidance, and they have been issuing. There aren't any coronavirus specific rules yet. There are some existing rules that apply to protecting employees from COVID in the workplace, but there has been lots of new guidance coming out, not just from OSHA, but from states as well, and in some cases, local governments. And then I advise people to look beyond the rules and look at applicable best practices that may apply to their industry or their workplace. And they are plenty these days, coming from all different sorts. And I'll talk about that a little more as we get further. Next slide, please. So as I mentioned, the coronavirus is novel to all of us. It's also novel to the OSHA folks. I mean, there have been previous flu pandemics, and again, some of the existing OSHA rules and standards apply. But But going back to that general duty clause and the need to just protect your employees from recognized hazards, whether or not there is a rules telling you what to do, I've been advising people to look at the existing standards and rules as sort of a framework, and where possible, go beyond what a specific rule says you have to do. Some of the existing requirements, such as conducting a hazard assessment of your workplace, determining where potential hazards could exist, things like communal settings where folks gather, that's a requirement to begin with, but it's more important than ever now to document that. Personal protective equipment, commonly known as PPE, it's more important than ever to determine what types of equipment or other personal protective measures can be used for your employees to help protect them. And then coming up with preparedness response plans, and that has there's lots of different names for that type of thing, but essentially a plan for protecting employees from, in this case, a virus that is transmitted in different ways. Next slide, please. So best practices, these are issued, they have been issued already from lots of local governments. In some cases, local governments have issued actual rules mandating specific practices. There's lots of industries have industry thought leaders that issue guidance. There are lots of thought leaders such as the Johns Hopkins School of Medicine, the Hoover Institute, the American Society of Industrial Hygienists. Lots of these organizations have issued best practices for employers to look at and to adopt where they can. In some cases, insurance companies have done it. And so it's a real important thing to do given the general duty clause, which again is a more vague, expansive requirement to keep your employees safe. And I know from personal experience that a lot of regulators look to best practices when trying to figure out what could an employer have been doing better to protect an employee from an injury or a fatality. And that's, OSHA has already indicated that they're going to be using the general duty clause for coronavirus cases. And a great example of the general duty clause being problematic for folks in terms of existing rules is there was a case, and there haven't been too many of them yet because obviously this is a new thing and litigation is not always quick, but a case in Texas recently where a restaurant would not allow a server, a waitress, to wear a mask. And typically that's allowed under OSHA. But here, given the novelty of the coronavirus and how uncertain it is how it spreads, and the fact that this person would be well within 6 feet, the appropriate distancing guidelines, the court found that the general duty clause applied and cited the employer for not protecting its employees. So those and best practices for that industry frequently recommend allowing almost all best practices today in lots of industries recommend allowing employees to wear masks if they want to, because it's a very reasonable anxiety. Next slide, please. So some of these questions, the next few slides, are things that we get asked about a lot, and they're again more important than ever given the novelty of this virus and the different potential liabilities that can arise from it. But under OSHA, oftentimes a lot of employers think that if they have maybe a vendor or a contractor or even a subtenant, someone else in their workplace, that their employers are responsible for them, and that you as the employer that controls the actual workplace are not liable under OSHA. But in fact, OSHA frequently, I would say even maybe the majority of times these days, at least here in North Carolina, cites the controlling employer when there's been a violation or a hazard for any employee. And so it's very important to come up with safety guidelines for your workplace and then communicate them to other employees or employees of other employers in your workplace, and to periodically check to make sure that they are following those guidelines, and to take action when they're not. Because again, if you are the employer that controls the workplace, the way OSHA sees it is that you have the ability to correct the hazard or to identify hazards and correct them. And so that's been something of a surprise to a lot of employers lately, and it's something that people should take to heart very carefully these days. This is especially even in multi-workplace buildings where you have different folks from different employers coming in and out sometimes of your spaces or areas that you control. It's important to communicate those safety guidelines to them. Next slide, please. Dealing with employee complaints, and they are plentiful these days. OSHA has received, both state and federal OSHA has received record levels of complaints from employees these days. And you can imagine most of them appear to relate to complaints regarding distancing, that the employer is not specifically requiring appropriate distancing, or things like protective equipment. And the complaints really are divided in two categories. There are informal complaints, which are anonymous, sort of general complaints, which get filed. And they fall into the category I just mentioned, where an anonymous employee just says, we're not spacing appropriately here and I don't feel safe. Then there are formal complaints where they're signed and they have very, very specific allegations. In either case, the OSHA folks are going to either inspect themselves, particularly where they think there's an imminent hazard or something, or at least ask the employer to address the complaint and explain what it is the employer is doing that makes the complaint invalid. And so what we've been advising folks to do is to explain, obviously to make sure you have appropriate safety measures and that you're not doing anything wrong, but to explain to the OSHA folks that this guidance is changing weekly, sometimes daily. Different state guidelines change, different best practices change. And a lot of employers, frankly, are just having trouble keeping up and, or in some cases, finding appropriate protective equipment in the market. And so it's important. The OSHA folks know that this is a tricky time for a lot of employers. And you certainly can't ignore the complaints and you certainly have to have a good response. But they've been instructed internally at the federal level to understand that I wouldn't say to ignore complaints by any means, but to take into account good faith efforts to comply. Same with inspections. If you actually do get inspected, and in the first few months, first two or three months of the pandemic, the OSHA folks were not coming out as much because they didn't want to get coronavirus either. But the agency has recently, I think last week, directed enforcement chiefs to start getting back out there. And so inspections are going to go up and employers are going to have to be able to respond to employee complaints credibly. Next slide, please. Illnesses and fatalities generally have to be reported to OSHA and have to be recorded. Coronavirus gets recorded as a respiratory illness. Initially, and it has to be reported, has to be a workplace incident. And initially, given how difficult it is to figure out causation, when and where exactly did someone catch the virus, it's difficult to show sometimes, many times, that it happened in a given workplace. And the OSHA folks recognize this, and the requirement for most employers to make a work-relatedness determination was temporarily suspended. But that's back on now. And so employers will have to show, if they are asked by OSHA, that they took reasonable steps to try and ascertain how exactly an employee had caught the virus and whether it was workplace related. And that will take different forms, such as seeing if they were in contact with another employee that had the virus, checking to see if maybe they had contact outside the office that resulted in the virus. And obviously there are privacy issues and employers have to be sensitive about that. But it's going to be important to make sure for employers to tell that whether or not there was a workplace issue. Next slide, please. So again, we hear a lot about the CDC these days and even other agencies, but the CDC is a very important part of the coronavirus equation, again, because the National Institutes of Health, part of the CDC, determines worker safety issues and occupational safety issues. And they've come up with general guidance, which was issued a while back for employers responding to the virus. They subsequently started issuing industry-specific guidance for different employers and different industries. And most recently, they've issued guidance for cleaning and disinfecting workplaces, because a lot of employers were asking questions about, when we reopen, how do we best clean up the office? What safety measures do we take to ensure that the office is as safe as possible? Also, when there's been a coronavirus incident confirmed in your workplace, affected employees and the affected part of the workplace need to be disinfected and cleaned. And so there's guidance now for that as well. And again, employers would be well served to not just look at OSHA rules themselves, but to check all these different types of guidance documents and best practices, because the general duty clause and that overall requirement to protect your employees in whatever form that should take is an evolving one. And it's going to be tricky for a while as we keep learning more about the virus, and until we have effective treatments or actually a vaccine. Next slide, please. So I'm going to turn it over now to my partner, Chris Smith, to discuss some of the liability protections that we have here in North Carolina for businesses. And I'll be back for questions. Thank you.
Okay, great. Good afternoon, everyone. Thanks, Steve. And thanks to our friends at NCEDA. It's always a pleasure helping them and partnering with them. I'm going to talk about legislative activity around creating liability protection for businesses during the corona pandemic. If we could go to the next slide, please. And we'll park on this slide for just a couple of minutes while I set the table for you about this discussion. Senate Bill 704 is the legislation that as well as law now that provides certain immunity protections for businesses and other folks arising out of corona. And but just before diving into that, I want to give folks a short news flash update. This coming from the General Assembly. I know a lot of folks in the audience here follow closely the JDIG issue, Job Development Investment Grants. And that, as many folks in the audience will know, was set to sunset January 1, 2021. We understand that there is agreement between House and Senate Finance Committee leaders on extending that. And if you want to follow it more closely, House Bill 1080 proposes a 9-year extension to the JDIG grant, which is very important public policy for job development and economic growth in North Carolina. And I know that development is important to a number of folks on this call, so just wanted to mention it. If all goes well, it will be voted through the House this week and then the Senate next week. So back to Senate Bill 704. Again, this is the law in North Carolina now. And in advance of today's webinar, you were provided with a package of materials. Contained in that package of materials is an alert that was prepared by my law firm that speaks to Senate Bill 704. And one of the things that's important to keep in mind as we're talking about this piece of legislation is, you know, this is new for everybody. Me here talking to you through the World Wide Web is kind of new. And everyone is working their way through these things. And Senate Bill 704 is really no different. It's legislation that came together quickly to try and address important concerns for our economy and for the business community. And it is by no means perfect. And the materials that we sent round to you this morning when you got your confirming email speak to that issue. And one of the documents in there, in addition to the alert, is materials assembled by the North Carolina Chamber. I'm on the executive committee of the chamber, and I also serve on the board of its legal institute. And, you know, while Senate Bill 704 does some very good things for our economy and the business community in North Carolina, it's not without its shortcomings. And those materials from the chamber point up some of the concerns that hopefully there's still the opportunity to address. There's also been some dialogue about, you know, could we do this on the federal level? Could it be done nationally? So that we're not doing it state by state, and provide appropriate liability protection to businesses nationwide. There was a lot of energy around that discussion early in the pandemic, let's say, but with politics getting tougher in Washington and the election getting closer, making the politics tougher, it doesn't seem that there's going to be progress on that. So really, this is an issue for us in North Carolina to address. And another item that is in those materials that were sent around to you earlier is pending legislation in House Bill 118. We'll get to that once we finish the discussion about 704, but that legislation is a perfect example of responding to, let's say, the imperfections in the piece of law that we're about to discuss, in an attempt to, you know, plug some holes and make things still better. Again, our legislators, our governor, everyone is responding in good faith, in real time, and working the process. And, you know, that process isn't perfect. Okay. Well, let's go to the next slide, please. So this is the meat of the coconut about limited business immunity that is provided under Senate Bill 704. And there's really, this legislation is interesting. Maybe I'm a lawyer, so I find this interesting, but the way it connects with what the governor is doing, and the legislature essentially delegating authority to the governor, you know, it shows government working the way it ought to work, which is folks working together in good faith to try and respond effectively to a real problem. And you'll see as we walk through this how what the General Assembly has done goes hand in glove with what the governor is doing through his executive orders. You'll see how these two groups of documents, the law and the executive orders, which are a form of law, tie together. So, limited business immunity. There is immunity provided with respect to claims from any customer or employee, or in the case of an essential business. There's immunity for claims from any customer or employee when you are an essential business. That can arise out of doing business with or while employed by the essential business. So the key thing there is to be an essential business. And I'll tell you in a moment the 4 ways one can become an essential business. And then the second bit of liability, immunity, and protection is given to those who are considered under the law an emergency response entity. Now, that definition is provided to you. It will stay on this slide, but that definition is provided to you in a later slide. But an emergency response entity is any business or not-for-profit that manufactures, produces, or distributes personal protective equipment, testing equipment, or ventilators, or processes corona testing results. So obviously, you know, we're all trying to solve this problem together, and we want businesses to provide those services. We want to give them some breathing space to do so. And this legislation, this immunity that's provided, gives that breathing space. And it's, a couple of examples of how this helps is we've got two companies here in North Carolina, and there are many more, but I'll just call out two, who qualify, in my view, as emergency response entities for what they're doing. Haynes, out in Forsyth County, quickly changed some of its lines to crank out PPE, which we all need. They're cranking out tens of thousands of masks, and that's something we want to support and protect, and this legislation does that. Similarly, LabCorp in Burlington is all over the testing issue, and that's something that we want to give them breathing room to protect that activity and encourage it. So those are two real world examples of how this emergency response concept plays out. The other is an essential business. Well, what's an essential business? There are 4 ways that one can be an essential business. And the legislation, back to my earlier comment about how you've got the General Assembly working together with the governor and vice versa on this, the General Assembly defines essential business as anything declared an essential business under the governor's Executive Order 121. You can find that on the governor's website if that's something you'd like to look at in more detail. But what Executive Order 121 does, it's the initial stay-at-home order that the governor issued. And it sets forth 4 categories of essential businesses. Number 1 is if you are determined by Homeland Security to be part of the essential economic infrastructure of the country. And those documents were put together at the very beginning of this multi-month process that we're in. And so if you're one of those, you're an essential business. Number 2, Executive Order 121 lists a whole number of businesses as essential, the ones that you'd expect, grocery stores, pharmacies, healthcare providers, et cetera, et cetera. Those are essential businesses entitled to this liability protection. Third, another interesting example of the branches of government working together and responding in real time to this moving ball of a pandemic. The governor's executive order delegates to the Department of Revenue the authority to identify additional essential businesses that weren't named specifically in the governor's order 121. So if you're a business that's not listed in 121, you can pull your facts together, pick up the phone, write a letter, contact the Department of Revenue and make your case for why you also are an essential business and should be entitled to these protections. And then fourthly, and finally, under Executive Order 121, you can be, and this is the way the legislation hangs together with the syntax of the order. The order says that if you are a business that follows social distancing requirements, and we're all generally familiar with what those are, if you follow them, you are, under the order, an essential business. And that's just the way all the language holds together. So if you follow all the rules very carefully, you qualify as an essential business under the order, which means you're an essential business under this legislation that we're going through right now. So, and a comment, Steve, a few moments about the general duty clause, something that can be intimidating for employers because it gives this sort of kitchen sink residual power to an inspector. I think it's worth considering that if you're entitled to immunity under North Carolina law, under this legislation that we're talking about, that really ought to weigh in one's favor and provide you protection under the general duty clause. So I thought I'd mention that in case anyone was was anxious about the discussion about the general duty clause. So if we could turn to the next slide, please. So when can you lose your immunity protection? It's the protection provided by Senate Bill 704, as you see in the highlighted language, shall not apply if there's activity constituting gross negligence, reckless misconduct, intentional bad acts. Basically, the rule of thumb is you could make a dumb mistake and keep your immunity. But what you can't do is, of course, you can't do something intentionally wrong, but you also can't do something super dumb. If you do something super dumb, you're not going to get the protection that you otherwise would be entitled to under this legislation. Also, it's worth noting that this legislation, while essential businesses are protected from claims by their employees, the language that's highlighted there, Chapter 97 of the general statutes, employees can, of course, still bring a workers' compensation claim. That's what Chapter 97 is. That's the Industrial Commission and where workers' compensation claims are. And the standard rules still apply, meaning the employee has the burden of proof to show that he or she more likely than not contracted corona while at work. Now, as Steve mentioned earlier, complicated fact patterns. There'll be some places where it'd be really hard to show that, but you can imagine a fact pattern where it actually might be quite simple. Somebody who is just at their home all the time, except when they go to work. That is, pretty good evidence that so long as nobody else at home is sick, that you got it at work. So this immunity provision expires when the governor rescinds the emergency declaration. Again, an example of how much authority that the governor has here, both to declare what's an essential business, as well as to determine when to blow the whistle and stop the game clock. But, unfortunately, we're all still seemingly in the thick of this and will be for a while. And so I don't foresee the governor doing that anytime soon. If we could go to the next slide, please. Right, so these are the definitions. I've discussed those with you some already. The emergency declaration that the governor has to rescind to end the immunity is Executive Order 116. And then under subparagraph 3 there, that mentions Executive Order 121 in connection with the definition of what's an essential business. So again, if you want to figure out, whether someone or an entity would be entitled to immunity under this statute, go to Executive Order 121 to see whether you're determined to be an essential business under the legislation. Okay, if we can turn to the next slide, please. And again, I mentioned these to you earlier. This is where in the legislation, and this legislation is in the packet of materials that went round to you earlier this morning. But here's your definition of an emergency response entity. Remember our discussion about Haynes and LabCorp and them stepping up to provide the kind of products that we all need and services that we need now. They've got that emergency response entity protection, and then the definition, again, of what an essential business is, and that's the governor's 121, plus any business that the Department of Revenue determines is essential. Okay, let's flip to the next slide, please. And the last slide here on Senate Bill 704 somebody had the wisdom in real time to put this severability provision in there, which tells the courts that this article, this immunity provision, shall be liberally construed to effectuate the public purpose, right? We need our businesses. It's private enterprise that's going to help lead us out of this by developing the vaccines, by developing the therapeutics, contact tracing, all those things. The instruction to the courts is you should liberally construe this to protect what needs to be protected to help us turn the corner here. And then the last section there, this is an example of things happening in real time. It says that the legislation applies to claims filed on or after March 27th. That's in section 4.14B. March 27th is a curious date. The law was actually passed on Saturday, May 2nd, signed by the governor, I think, on Monday, May 4th. So all sorts of interesting issues come out of this legislation, because it's at least says that it's meant to be retroactively effective. And you can imagine lawyers are going to be figuring out with the courts what all that means and whether that can be done. Let's go to the next slide, and this will be the last topic that I cover in my prepared remarks before we floor to your questions. And I see that we've gotten a number. This is House Bill 118, which I mentioned to you at the top of my comments in connection with, talking about how Senate Bill 704 done in real time, people doing their best, and it not being perfect, and there being other issues that potentially should be addressed. Remember, Senate Bill 704 only applies and provides immunity to, if you're an essential business, about the 4 ways under Executive Order 121 that you can be considered an essential business, or if you're an emergency response entity, like what LabCorp, Haynes, and others are doing. Well, there is concern in from a number of places that's maybe not all, just doesn't cover all that we need. Let's go to the next slide. This legislation was introduced 2 days ago. And here you'll see that this proposed addition to immunity protection will apply to persons. And that's my underlining and my highlighting. And you'll see that essentially applies to everyone in North Carolina except, cats and dogs. I mean, it covers individuals, corporations, LLCs, joint ventures, governmental subdivisions, public, on, and any other legal entity. So this is meant to bring in a much broader group than just essential businesses and emergency response entities. Go to the next slide, please. And that immunity, and this is the, again, the meat of the coconut here for this proposed legislation. You can look at B and C if you're curious to. It's included in the materials that were sent round to you. But the immunity to, remember, every person defined on the last slide, which gets to everybody on this call, everybody except cats and dogs in North Carolina. This immunity will apply to any claim for relief from any act or omission arising out of Corona. And again, the only exception, the way you lose that protection, is if you do something super dumb or you're a bad actor. So you can make a dumb mistake, you just can't make a super dumb mistake. It's my understanding that the prospects for this legislation are good in the Senate. It's unclear about the House, and time will tell. The next slide, please. And again, back to the concept of filling in and trying to make better what Senate Bill 704 tried to do. The applicability of this House proposed legislation would apply to claims arising no later than 180 days after the expiration or rescission of Executive Order 116. You'll remember 116 is the order where the governor declared that this is a state of emergency. So when he rescinds that under Senate Bill 704, when he rescinds it, the earlier legislation, when he rescinds 116, the immunity ends that day. That was perceived to be, a miss in Senate Bill 704. And this provision says, well, the governor ends and rescinds 116, and 180 days later, the immunity ends. Because you could imagine someone could catch the virus and not know from one of the covered businesses and not know until after the governor ends the emergency period. So you can see why that was thought to be a gap that needed filling. And so with that, that concludes my prepared remarks, and we'll now bring Steve back and open it to your questions.
Thanks, Chris. If I could just say one thing, because Chris raised a very important point about legislative immunity here in North Carolina and how it may interact with the federal general duty clause. It's important to note that for businesses here in North Carolina, it's important to note that there is a federal act and a federal agency, but some states like North Carolina have obtained approval to administer the OSHA program here in North Carolina by themselves. And so it's important to note that we have as far as state agencies go, this is a fairly business-friendly state agency. It is led by a Secretary of Labor who was previously a businesswoman herself. And I agree with Chris. I think that by and large, I'm not sure this has been tested yet, but I think that by and large, the General Assembly's actions to grant certain limited immunities to essential businesses probably will help employers here in North Carolina in terms of general duty clause citations or the lack of. So just wanted to mention that.
Thanks, Steve. So Emily, with that, we can turn it to you for any questions, and you might leave the slide on the question slide. That would be fine. Yeah.
Thank you guys so much. We did have a few come in. We've got about eight or 10 minutes left, so we'll just kind of run through what we can. On the liability, one question we had was, how does the North Carolina business immunity compare to other states?
Yeah, so everything is happening very fast. I think each state probably is finding itself in a position like what North Carolina is in that we haven't acted perfectly and done everything that we want to do. Not every state has created an immunity. I can't give you the exact number of states that have, but I can tell you that we sort of, my read of it is we sort of fall somewhere in the middle on scope, that there are a number of states that are closer to the legislation, House Bill 118 that was introduced this week, and that there are a number of states that don't carry the issue as far as we've already carried it.
Thank you.
Sure.
Is the immunity broad enough for you, do you think?
Well, so I've got a good deal of sympathy for the efforts to try and fill some of the gaps. You know, I think it's clearly a gap that the immunity that exists now will end on the day that the governor rescinds the public emergency. You can imagine that things that happen before then might not manifest until later. That seems a clear gap that ought to be filled. I also think that the definition of essential business and emergency response entity, you know, it's worth giving some thought to whether we're sweeping up everyone that we ought to. And yeah, and it's a tough question how far to take it, because we don't want people to be given incentives to do the wrong thing. But you know, this is a singular moment. Everything is an issue of first impression, and I think we'd be well served spending our time trying to come up with solutions and how to solve the problem, rather than worrying about folks suing each other.
Fantastic. And folks, as a reminder, all attendees, you can enter a question into the Q&A box. The Q&A box is a button at the bottom of your screen. You'll just open it up and type in your question if you have any. This next question, I think, refers to the safety part of the presentation. Can employees refuse to come to work or require face masks or other protective equipment because of COVID fears?
Generally speaking, an employee can't refuse to come to work unless they have a credible basis for believing there's an imminent hazard in their workplace. And again, this is as it relates to OSHA, and that's true in North Carolina as well. That said, lots of guidance has been issued by both OSHA and the CDC and state governments suggesting that employers consider remote working where possible, staggered shifts, you know, just lessening the chance of contact and the virus being transmitted. The other part, I think, related to face masks, employers are strongly suggested to provide face masks to their employees. It's a little bit tricky because for some employers, because once you require a piece of personal protective equipment, that triggers other OSHA obligations, such as the requirement to train the employees on the equipment, the need to properly maintain the equipment. And so I think that's why they've not flat out mandated that at the federal level. But employers would be well served to allow face masks and to provide them.
And Steve, maybe just to add a follow-on comment to that, under the governor's executive order and definition of essential business, in order to preserve your characterization as an essential business, you have to direct those who can, at present, those who can work, who can telecommute, that they should telecommute. So there's, you know, that piece to it as well.
And this next question is sort of related to all of that. Will employees bring workers' compensation claims against our company? Will they be able to do that?
Yeah, so that's, we spent a moment or two mentioning that. Yes, employees can absolutely bring a workers' compensation claim, but you know, there is community spread of this virus. And so what an employee needs to be able to prove is that she more likely than not contracted the virus at work. If she contracted it at home or out shopping or anywhere else, she is not an eligible workers' compensation claimant. So that's, we all can apply our own common sense here and sort of see how there could be very difficult proof problems for an employee trying to make a workers' compensation claim because of the community spread dynamic. But you can also see an employee who, if they're essentially living at home and only going out to go to work, that they'll be able to demonstrate that, if they think they contracted it at work and nobody else at home is sick, well, that kind of looks like they probably caught it at work.
Sure. Just a couple more here and then we can wrap up. What are the pros and cons for an employer providing health screenings to all employees and visitors who enter the workplace?
Well, providing health, and when we say health screenings, that can encompass different things. Some businesses have questionnaires you fill out explaining things like, have you been in contact with anybody that has had a confirmed case of COVID? Other places have used temperature checks, for example. And there are logistical challenges to, for example, temperature checks, because if you have, if you're a large business and you have hundreds of employees coming to work at a certain time and have to socially distance them at the same time as taking all the temperatures, that can be a daunting task. I remember early on an employer asking us, they just couldn't find enough thermometers at that time locally. But doing some sort of health screening is a great idea, because it's one more thing you can show that you took a step to make sure you're protecting your employees. A question we've gotten asked a lot is, should I, especially when you're in a multi-tenant or multi-office setting, is should we be taking temperatures or doing health screenings for others' employees before they come into the building or before they get into an elevator with our folks? And that's a tricky issue because you don't want your employees to be playing doctor with another employer's employees. You also then trigger ancillary OSHA requirements regarding maybe having to train that employee and properly fit them and that sort of thing. So I think screening your own employees is a great idea. It really is an employer by employer issue. I think if you have sort of a small dentist office, for example, and you have patients coming in at staggered times, it's not logistically difficult to do temperature checks, but it's logistically has to be worked out as well.
Great. And then the last question we had is kind of about the nuisance lawsuits. Can you explain what's happening with the nuisance lawsuits to try and shut down companies?
Yeah, sure. So what the question is getting at there is, there have been a number of virus breakouts at places like, food plants. Tyson's food plant in, I think, is Dakota, and a couple of other places, and where plaintiffs' lawyers have been always looking for opportunities, and folks being dissatisfied with the government response, they have brought claims under nuisance law to say, hey, that plant should be shut down because look what's happening there. And these claims have generally been unsuccessful. We haven't seen them yet in North Carolina. I think we're apt to see something like them at some point just because of the inventiveness of the plaintiff's bar. I think the right approach to these is, everybody, there's been sort of a cottage industry that has developed out there where folks are bringing suit against the governor saying the executive order is being applied unfairly to me, my business needs to be allowed to reopen, my bowling alley, my amusement park, that sort of thing. And what the courts have said to this point, and all those cases were consolidated in front of Judge Gale from our business court, and he's basically said, listen, I wear a black robe, I'm a judge, I know the law, I don't know epidemiology, We've hired Governor Cooper, and Governor Cooper has hired Dr. Mandy Cohen as our expert. And those are the folks who are expert at these issues. And at least for now, they're being allowed to manage them. And I think that that's kind of the way the courts would view in North Carolina a nuisance claim against a business. You know, this really isn't a decision for a judge in a robe to make. It's for someone else to make that decision. We trust someone else to do it. So.
Great. Well, thank you both so much for answering these questions and being with us today. I'm going to invite Mark back to give our closing remarks. Take it away.
All right. Thank you to our experts, Chris and Steve from Smith Anderson, for sharing the valuable guidance with our NCDA members. We appreciate the firm's sponsorship of today's webinar. And also one final shout out to the annual sponsors we saw earlier. Support from all these organizations and companies is critical to NCDA's mission. Join NCDA next Tuesday morning at 10:30 for our next webinar, How to Support Your Local Businesses with Zoom Business. Watch your email for additional information on that and on plans for our annual conference in Wrightsville Beach, August 25th through the 27th. Thank you to all our members and guests for participating with us today. We hope to see you soon. Until then, stay safe, stay confident, and stay connected. Thank you, guys.
Thank you, Mark.
Thank you.